Hello everyone and welcome to Nerd Mela. This is Brahmavadini and I have with me Shekhar.
Hello.
So today we will be taking a look at the Supreme Court's decision to examine the issue of faith-based customs that violate fundamental rights. And for this, a 9-judge bench led by CJI S.A. Bobde has been set up, which will examine the larger issue and also set guidelines for judicial scrutiny of petitions that have raised the issue of, or that will raise the issue of clash of faith versus fundamental rights. And here it is important to note that the Supreme Court will have to do like a balancing act between the rights versus faith issue. And over the course of this discussion, we will look at some of the past cases that have pitted faith against fundamental rights. But before we move forward, please remember to like, share and subscribe. You can also follow us on Twitter at NerdMela. But let's get back to the discussion. So the first question that we have to ask is, why was this examination necessitated?
Yeah, Brahma, so we know about the much debated Sabrimala verdict of 2018. The judgment ruled that all pilgrims, regardless of gender, including women in the menstruating age, should be allowed to enter the temple. And the Supreme Court bench held that any exception placed on women because of biological differences violates the Constitution, and that the ban violates the right to equality under Article 14 and freedom of religion under Article 25. You can check what the articles are on your screens. And this verdict led to widespread protests and people calling the verdict as disrespectful to Lord Ayyappa. And after that, there were multiple review petitions filed in the Supreme Court as well.
But the Supreme Court has said that that this time it's not hearing the pleas that seek review of the Sabrimala verdict, and it is only going to deal with the larger issue of the faith versus fundamental rights. And for this, it has set out 7 questions of law to be examined by the larger bench. And so these include very quickly the interplay between freedom of religion under Article 25 and 26 of the Constitution, then the need to list the expression constitutional morality, and also the extent to which courts can sort of interfere in religious practices or whatever, or inquire into the particular religious practices, and so on and so forth. The questions have been put on your screen right now. But also most recently, the bench has also asked the lawyers, which gave these set of questions, to reframe the issues and or add to them, as they said that these submissions are quite broad. So this again brings into light the fact that the Supreme Court faces a difficult balancing question, something that we mentioned earlier. And so now we'll try to understand why is that.
So when we look at these questions, firstly we would have to look at the freedom of religion as an individual right under Article 25, and the right of religious denominations to manage their own affairs in matters of religions, which come under Article 26, and both of them are recognized under the Indian Constitution. And this is because India is basically a pluralistic society with different groups and their different cultures. And to protect this diversity, these rights have been enshrined in the Indian Constitution. And the second thing that is of importance in this debate is that there have been cases of oppression and discrimination by a certain section of society to the other. And sometimes these have taken place under the name of religious or social practices. And to safeguard the rights of individuals and minorities, the Constitution provides for the possibilities that there will be a time when certain sections of the religious and cultural communities may need to be protected from these discriminatory social practices.
Which is why in the Article 25, it is prefixed with the words, this is in quotes, subject to public order, morality, health, and to other provisions of this part. And it is understood that the two articles, which are the Article 26 and 25, which we are discussing, are subject to other fundamental rights that have been guaranteed by the Constitution. And also, there is also this fact that the provision for religious freedom under Article 25 closes with a final clarification that states that nothing in this article shall prevent the state from making laws providing for social welfare and reform. So social reformation has not been eliminated from this. So right now the Supreme Court's task is to find a balance that also protects the rights of the right of practicing religion and also the rights of the individual, which is what the entire debate is about.
So the next question is, what has the Supreme Court done in cases where there is this question of rights versus faith?
So the first thing is that the Supreme Court has this sort of a litmus test to decide this faith versus rights issue.
Yeah.
And it is whether the religious practice in question is essential or integral to the concerned religion.
And only the essential practices are safeguarded by the Constitution, and the rest are open to interpretation and state interference. That these practices are secular, and the state can interfere in these rituals.
So, and we can see that there have been examples in our country's past as well. First of all would be the example of the 2004 verdict that the performance of Tandav dance is not an essential tenet of the religious faith of Anand Margis. And this despite the fact that the followers of the religion believed that this to be the case, that they are the only ones who can perform this dance. So this is also where the court intervened to give a verdict saying that that's not the case because it's not an essential practice. And there have been questions raised whether a secular court should be able to, or would be able to rather, rule on a religious issue. And the court has also reiterated multiple times about this question that the essential religious practices is the only way to find a middle ground to respect the religious autonomy and also to enforce individual rights. And any, like you mentioned, any other ritual falls outside this.
It can be subject to the scrutiny of state interference or the scrutiny of the courts. Another example of such a verdict would be the 2017 Triple Talaq verdict by the Supreme Court. And in that ruling, the Supreme Court had said that the practice is not an integral part of the religion.
Which is why it was...
it was outlawed by the Supreme Court.
And the other example, another example of this would be the Supreme Court intervention in the temporary ban on the practice of Madesnana, which is a centuries-old ritual which takes place in this temple in Karnataka, Kuke Subramaniam temple. And the practice involves people belonging to scheduled castes and scheduled tribes to roll over the food that is half eaten by Brahmins in order to cleanse themselves. And the thing is that in 2012, the High Court, the Karnataka High Court, had put a stay on the practice and allowed a sort of modified version to be practiced, but which was in which, like, voluntarily, if people want to do engage in this, and I think the food should not be eaten by anybody, but they can roll over.
That should be prasad offered to the gods.
But then later, 2 years later, it quashed its own order, saying that the ritual in its original form was not discriminatory, after which the Supreme Court ruling came. So the whole point of these examples is to sort of show that, of course, except for the Tandav and Anandamagi's case, the rest two examples are a question of human dignity for a certain section of the community. And we have mentioned this in our earlier podcast on secularism as well. The link is on your screen right now. That our constitution sees religion as an integral part of for any Indian, which is why there is this tendency in our country that more often than not, religious sentimentalities define social sanctions, and here is where sometimes discrimination also seeps in.
And speaking of discrimination, there's an article in the Hindu by lawyers Suhrit Parthasarthi and Gautam Bhatia.
They sort of try to explain how social sanctions lead to discriminatory practices which may or may not be covered under the constitution.
So they talk about the practice of untouchability, which is prohibited by our constitution. But there is another practice of excommunication, a practice in which the head of a community can expel, so-called rule-breaking members and exclude them from any form of interaction with their former friends and their families. So
this is not as per the definition, not exactly untouchability, but this is some sort of very exclusionary practices.
Your social boycott of individuals.
So this helps us understand that these social sanctions are discriminatory, and people who face these sanctions should have the option to approach the court to safeguard their rights. So which again brings into perspective this whole issue of the faith versus individual rights. We see it from another light. So the thing is, when the court is trying to find a middle ground to respect the religious and individual rights, so the first thing that has been going on till now is that the court can maintain the essential practices test, which is like whether a practice is integral to the religion. And then the other way, which should also be in consideration, is to ask whether the effect of the disputed religious practice is causing any harm to the individual rights.
Yeah.
Like we saw in the case of Madhesnana, it's a question of human dignity.
Yeah.
It's violating human rights.
And here we can remember the Bombay High Court judgment, which ruled that the exclusion of women from the inner sanctum of Haji Ali was a violation of equality.
Yeah. Yes, of course. And so here the question was not about essential practices, but whether the effect, whether intended or not, was sort of to subordinate or exclude a certain section of community.
Yeah.
And since the conversation has again come back to exclusionary practices, like we mentioned earlier as well, that religious sentimentalities often define social sanctions in our country, there is also this fact that the norms and practices that have to be followed by communities are decided by like a group, like a certain group of people or like a community leader, and then it is enforced upon the rest of the society. And those who oppose it are often excluded, which is where the constitution can help and ensure that those who are discriminated can approach the court. So to sum it all up, we have understood certain points. The first thing is that the Supreme Court has a difficult task at hand to ensure that that we do not take for granted the right to follow religion in our country, and also ensure that that individual liberties are not hampered.
Yes.
And since we are talking about this, very quickly I want to mention that the kind of issues that the court is looking into is that the practice of female genital mutilation in Bohra Muslims and the right of Parsi women to enter the fire temple. I think after they marry outside
outside their religion.
Then they are banned from entering or something like that. So these are the issues which we have to keep in mind. The strength of our country is its diversity, and we have the constitution and code to ensure that the diversity thrives and at the same time individual rights are not overlooked. On that note, we end our conversation for today. I am Brahma.
I'm Shekhar.
Thanks for watching. Please remember to like, share and subscribe, and stay tuned for more.